Hello, everyone, and welcome to Uncivil Law. We are going to be doing a slightly different Supreme Court React today because we are going to be talking about cases dealing with public health and public health emergencies and the power of governments to institute policies relating to the public health. So, given the issues that are currently going on, and I figure that this is a good topic to cover. And normally what we do on Supreme Court React is we do oral audio React. So we do the oral audio of the case, and sometimes we read the decision. Well, we don't have oral audio today because we're going way back in time. We are going back to the early 20th century. In fact, in one case, October 1900, that technically might make it the 19th century, depending on how you count these things. So we're going way back in time to discuss some cases that deal with public health, and we're going to read these cases and see what they have to say. So I figure this is a good opportunity to talk about what the government and the state can do when it comes to public health issues. What can they require? What can they impose? What is the power of the government to deal with public health? So we're going to read these cases, and we're going to discuss what they say. Starting with, and there's no way I'm going to get this pronunciation right, so I apologize in advance. Starting with Compagnie Francaise de Navigation à Vapeur versus State Board of Health, Louisiana. This was argued October the 29th in 1900 and decided June the 2nd of 1902. And we're just going to read it, and we're going to see what it has to say so we can see some of the law that deals with these issues. United States Supreme Court decision from Justice White. This action was commenced in the state court against the Board of Health of the state of Louisiana and three persons who were members of the board, and whom it was sought to hold individually responsible for damages alleged to have been suffered from the enforcement of a resolution adopted by the board upon the theory that the resolution referred to was ultra vires, which means beyond power, outside power, illegal, and hence the members of the board who voted for it were personally liable for any damages occasioned by the enforcement. The board was thus described in the petition. So the argument is that this board of health in Louisiana did something illegal outside its power, and that these government officials, therefore, should be held personally liable. This is way before 1983 ever existed, by the way. So if you're waiting to know about 1983, well, it hadn't been invented yet. So we're under different theories here. The petition says, quote, "The defendant, the State Board of Health, was a body created by an act of the General Assembly in the state of Louisiana in the year of 1898, with power to sue and be sued, domiciled in the city of New Orleans, and composed of 7 members, whose duty it was, by the provisions of the act, to protect and preserve the public health by preparing and promulgating sanitary code for the state of Louisiana, by providing for general sanitation of the state, with authority to regulate infectious and contagious diseases and prescribe a maritime and land quarantine against places infected with such disease." Yeah, so this language is a little relevant to issues we might be talking about. What can the government do? This is the case that we're dealing with from Louisiana, right? So Louisiana has this authority to enact for any infectious and contagious disease, maritime and land quarantines. Kind of relevant, seems to me. Again, I need to point out that we're discussing a law that existed from 1898. So I don't know whether this law exists today, but I'm reasonably confident that some version of it does, because I'm pretty sure every state has some emergency authority somewhere in its statutes. So, this law might have been modified in the last 120 years, but it's probably close enough to what exists today that we can still hold the logic of it over. It was asserted by that the plaintiff, a corporation created by and existing under the laws of the Republic of France and a citizen of France, that on or about September the 2nd, 1898, caused its steamship Britannia to be cleared from the ports of Marseille, France, and Parmello, Italy, bringing disease to the United States, for New Orleans with cargo of merchandise and with about 408 passengers, some of whom were citizens of the United States returning home. Also potentially relevant to legal issues we're dealing with today, right? The ability of the government to restrict and quarantine even as it relates to citizens of the United States. Potentially important. Let's carry on. And others who are seeking home in the United States and who intend to settle in the state of Louisiana or adjoining states. It's also worth pointing out that at this point in history, immigration law was quite a bit different than it exists now. So these are people who just want to get off the boat and become citizens of the United States, which, I haven't looked up immigration law recently from 1898, but probably was legal. Immigration law was a little bit different in 1898 than otherwise. So these people are on a boat and just want to get off and become Americans. Probably legal at the time, or some version of it. Yeah. And who intend to settle in the state of Louisiana or the adjoining states, and that all the passengers referred to at the time of sailing were free from infectious and contagious diseases. So they're arguing that all 400 of them are healthy. Fine. It was further averred that on September the 29th, 1898, the vessel arrived at the quarantine station some distance below the city of New Orleans. It was regularly inspected and found, both as to the passengers and cargo, to be free from any infectious or contagious disease, and accordingly was given a clean bill of health, whereby the ship became entitled to proceed to New Orleans and land her passenger and discharge her cargo. This, however, it was asserted she was not permitted to do so. She, in this case, being the ship, because, ships are sometimes referred to as she. So she, in this sentence, is the ship. That she was not permitted to do so because on the date last mentioned, at a meeting of the Board of Health, the following resolution was passed. So we see what's happened, right? There was a quarantine where you inspected the ship. The ship was found to be in a clean bill of health status. And sometime between the time that happened, the time it actually arrived at port, there was a resolution passed by the Board of Health of New Orleans. So this would be example this would be example relevant to anyone who was on a plane or about to be on a plane or a boat for that matter when Trump announced his travel ban. So this would be relevant to people who were in the air at the time. To the extent that they existed, could they be required to obey a quarantine that was enacted after they boarded, potentially? So this was the resolution passed by this Board of Health. Resolved that hereafter, in this case of any town, city, or parish of Louisiana, remember, parish is what Louisiana calls counties, because Louisiana has to be different because France. So parish just means county. Any town, city, or parish of Louisiana being declared in quarantine, no body or bodies of people, immigrants, soldiers, or others shall be allowed to enter the town, city, or parish, so long as said quarantine shall exist, and the president of the board shall enforce this resolution. So basically, if there's a place, a city in this case, that has a quarantine, no one can enter. This applies to people even if they're in a healthy status, which, why you'd want to enter a city if you're in a healthy status and they're under quarantine, one can only begin to imagine. But that is the factual posture. If you are healthy, do you have the right to enter a town that's under quarantine? Why would you? But okay. It was charged that in order to enforce this resolution, the president of the Board of Health, who was one of the individual defendants, instructed the quarantine officer to detain the Britannia at the quarantine station, and the president of the board addressed to the agent of the steamship following communication explanatory of the detention vessel. This would also be relevant, for example, to all those people that were caught on that cruise ship or future cruise ships. This is stuff that we might be dealing with, yes. The government says, referring to the detention of SS Britannia at the Mississippi River quarantine station with 408 Italian immigrants on board. Well, that's a little bit of a mistake, at least according to the court. But remember, this is the Department of Health communicating to the ship. But in fact, some of these people were U.S. citizens, so not all of them were immigrants. But with the 408 Italian immigrants on board, I have to inform you that under the provisions of a new state Board of Health law, Section 8, of which I have enclosed a marked copy, this board has adopted a resolution forbidding the landing of any body of people of any town, city, or parish in quarantine. Under the resolution, the immigrants now on board of the Britannia cannot be landed in any of the following parishes of Louisiana, namely Orleans, St. Bernard, Jefferson, the right bank. Who knows what's going on the left bank, but oh well. St. Tammany, there's no way I'm going to get this right. Plaquemine, St. Charles, or St. John. You will therefore govern yourself accordingly. So the Board of Health has forbidden this ship from docking at any of these places by resolution. You may not do this. You must govern yourself accordingly. So I guess you could land somewhere else and then walk to there, because this is 1898, so I'm not even sure cars exist at this point in history. So you could walk or take horses. The president of the Board of Health, it was alleged, moreover notified that the agent of the ship that if an attempt was made to land the passengers at any place contiguous to New Orleans, which I guess by contiguous we mean immediately bordering, such place not being in quarantine, a quarantine against such a place would be declared, and thus landing would be prevented. So thinking ahead, the Board of Health said, hey, if you're going to try to get around this by trying to disembark your passengers at a parish, read county, because it's Louisiana, if you're going to put them at a county adjacent to try to get around this, we've thought ahead. We're just going to declare that county also to be in quarantine, so you can't get off there either. So in the event that you were thinking about getting around our exception, no, we're not going to let you do that. It was averred that while the resolution of the Board of Health purported on its face to be general in its operation, its truth was it was passed with the sole object of preventing the landing of the passengers from the Britannia. So here we can see like the face of it versus as applied. Today we would call that a facial challenge versus an as applied challenge. So on its face, it appears neutral. In reality, it was designed specifically to prevent these specific people from disembarking, or so it is stated. Which, given the timing of it, is not necessarily a unreasonable argument. There could be other reasons, but given the timing of it, that they're trying to prevent specifically this ship from disembarking, seems plausible. And it was demonstrated because no attempt was made by the Board of Health to enforce the provisions of the resolutions against immigrants from Italy coming into the United States via the port of New York and thence reaching New Orleans by rail. Well, that's a lot of different travel, but okay. And that after promulgation of the resolution, more than 200 such persons, varying in groups of 30 to 100 in number, have from time to time been permitted to enter the city. So basically arguing that you're not being equal under the law. You're not showing equal justice under the law. Different people are being held to different rules. You know, you let these people immigrate, but not these people. You're treating us differently than you've treated other people, even though we've shown no signs of sickness. Okay. It was averred that the action of the board was not authorized by state law, and if it was, such law was void because it was repugnant to the provision of the Constitution conferring upon Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. This case is so old. This case is so old. Wicker v. Filburn hasn't happened yet. And, you know, interstate commerce law as we know it and love it has not yet been invented. So, you know, whether or not the federal government can regulate things under interstate commerce is an open question at this point in law because this case is so old. But we're not here to deal with interstate commerce stuff. We're here to deal with the public health stuff. Averring that damage had already been entailed to the extent of $2,500. Remember, this is $1,898, for which not only the board but its members who voted for the resolution were liable, and reserving the right to claim future damages that might be entailed by the further enforcement of the resolution. The petition asked for an injunction restraining the enforcement of the resolution in question and asked judgment against the board and its members named for $2,500. Yeah. The court declined to allow a preliminary restraining order, and upon a hearing of rule to show cause, we know show cause hearings, those still exist today in law. We know about show cause hearings. Upon a hearing for a rule to show cause, the injunction was refused. So there was a show cause hearing, and they said, no, we're not going to give you an injunction. This case, again, being so old, I don't know what the laws on injunctions were at the time. Under the rules today, an injunction is considered discretionary in any event. It is an equitable remedy, never entitled to. But the cases saying that are probably younger than this case. So I'm not sure what the rules on injunctions were at the time, but no injunction for you in any event. The order of the Board of Health, which was complained of, continued therefore to be enforced against the ship, because no injunction was issued to the contrary. So of course it was. Subsequently, the plaintiff filed a supplemental and amended petition. It was reiterated that immigrant passengers on board the Britannia were free from disease when they shipped and at the time of their arrival. Which, again, is not exactly an invalid argument, because when you're traveling by ship in this period of history to get from Italy to New Orleans, you're probably on ship for what do we want to say, 3 months, 4 months. So if there's going to be some sort of outbreak, we probably would have noticed by this point. It's a fair point. And in addition, it was alleged that the steamer with immigrants on board had sailed from the port of departure prior to the declaration by the Board of Health of the existence. Again, this is more of an estoppel idea, right? Or at least, not necessarily estoppel, but reliance interest, I guess would be better. It's like, we did this before you ever passed your resolution, so we shouldn't be held to it. People have spent money. People have spent money to board this ship. People have bought plane tickets, and people have bought hotels, and people have bought things. This is the same line of argument, right? It was alleged that in consequence of the insistence of the Board of Health and its members in enforcing the illegal order refusing to allow the landing, the steamer had been obliged to proceed to Pensacola, Florida, where they landed, and the steamer returned to New Orleans for the purposes of discharging cargo. This is also potentially a violation of the Jones Act, which, again, I'm not sure existed at the time. But because you went from, it's a foreign ship that went from one U.S. port to another U.S. port without an intervening international port in between. So this is also potentially a violation of the Jones Act. But then again, I'm not sure whether the Jones Act exists, because it's 1998. The damages resulting from all this was averred to be $8,500 besides the $2,500. We got an additional $8,500 in damages on top of what we already claimed from all this. And a judgment for this amount, in addition to the previous sum, was also asked against the board and members thereof who were individually made as defendants. So we're suing them in their individual capacity. It was moreover averred that it was in violation of the laws of the United States and rules and regulations made in pursuance thereof relating to quarantine and immigration from foreign countries into ports of the United States, and especially acts of Congress approved February the 15th, 1893, and acts of Congress of March the 3rd, 1893, August the 3rd, 1882, and June the 26th, 1884, and the rules and regulations made pursuant thereof, and the treaties now existing between the United States on one part and the Kingdom of Italy and France on the other part. Someone suggested the Jones Act was 1920. Could be. So yes, the Jones Act did not yet exist. But this would have violated the Jones Act had it existed, but it didn't. The defendant filed a preemptory exception, of no cause of action, which would today be called a Rule 12b-6, motion to dismiss for failure to state a claim. Today we call it a 12b-6 motion. So what things are called have changed a little bit, but the logic of it is the same. And the suit was therefore dismissed under the motion to dismiss. On appeal to the Supreme Court of the state of Louisiana, the judgment of the trial court was affirmed. So no, you can't come into our state. You're not allowed. And now we're at the United States Supreme Court. All right. So here are the facts. Here are the facts as relayed by the United States Supreme Court as part of its decision. Here are the facts. A group of Italian and some U.S. citizens left Italy, and I think they mentioned some other country in there, but yeah, I think they mentioned Cologne, France. So a group of immigrants and U.S. citizens left Italy and Cologne, France, traveled by ship to get to New Orleans. At the time they left, there was no regulation against them coming in. And they were all healthy by a bill of health that was provided by their initial inspection. However, by the time they actually got to the actual port to disembark, there was another rule in place. The rule said, no, you can't disembark because all these places are under quarantine. So even though you're healthy, you can't come in. No, you can't come in. And they said, but we're healthy. And they said, we don't care. And they went to trial court and said, we want stuff. And the government said, we want to file a motion to exclude under, what would be 12b-6, although it didn't exist yet. And they won, and they also won at the trial court of Louisiana. So now we're at the U.S. Supreme Court to figure out whether or not this regulation is legal. Justice White, after making the foregoing statement, delivered the opinion of the court. The law of Louisiana, under which the Board of Health exerted its authority, which is complained of, is found in Section Act of the Act, which was enacted in 1898. The portion of the section which is essential is as follows. The provision which is more directly pertinent in the case at hand is being italicized. So we're going to say this is the relevant law and also italicize it. I'm not sure if it's actually italicized or not. No, not it. Looks like the italicized have been lost in this particular recitation. So we'll just imagine. Or I'll tell you what should be italicized. How about that? In case that any parish, town, or city, or any portion thereof, shall become infected with any contagious or infectious disease, to the extent that threatens the spread of the disease to other portions of the State Board of Health shall issue proclamations declaring facts and ordering in quarantine, and shall order local boards of health in other parishes, towns, and cities to quarantine against said locality. So, you will enforce this, agent of our state. And shall establish and promulgate rules and regulations, terms and conditions upon which the intercourse with said infected locality shall be permitted. Intercourse here does not mean sex. It just means interaction. So, just handshakes or just commingling. It doesn't mean sex. And shall issue to other local sanitary authorities instructions as to measures adopting a quarantine against persons, goods, or property coming from the infected localities, and these rules and regulations, terms and conditions shall be observed and obeyed by all other health authorities, provided that should any other of the non-infected portion of the state desire to add to the regulation, rules, terms, and conditions already imposed by the state, they may do so upon the approval of the State Board of Health. The State Board of Health may, in its discretion, prohibit the introduction into any infected portion of the state persons acclimated, unacclimated, or said to be immune. So that would be healthy people. So persons acclimated would be persons infected. That would be persons acclimated. So you can prohibit into the introduction into an infected portion, persons acclimated, that is, persons infected or previously affected, unacclimated, persons not affected, or immune. So all the people. When in this judgment, the introductions of such persons would add to or increase the prevalence of the disease. The State Board of Health shall render the local boards of health all the assistance in their power and which the condition of the finances will permit. So this is pretty broad language, right? This is pretty broad language. So basically it says, in short, that the Department of Health of any parish, read county of Louisiana, can publish a regulation that would apply to all the state and prevent any interaction, and all the rest of the state must enforce it. And it can prevent the admission of even healthy people, even people known to be healthy, because it's a quarantine. The Supreme Court of the state of Louisiana, interpreting the statute, held that it was empowered, the board, to exclude healthy persons from a locality infested with a contagious or infected disease. And this power was intended to apply, well, to persons seeking to enter the infected place where they came from without or within the state. So whether they came from externally or internally within the state, from place to place within the state or across state lines, or nation lines as the case may be. So the Supreme Court of Louisiana says, the law does not permit the boarding to prohibit the introduction of persons from one portion of the state to another and an infected person of the state, but evidently look as well to the prohibition of the introduction of persons from points outside the state to any infected portion of the state, as to the object in view would be to accomplish the subsistence and suppression of the infectious and contagious diseases, and to prevent the spread of the same. It would be difficult to see why parties from outside the state should be permitted to enter into infectious places, while those from different parishes should be prevented from holding interactions with each other. So basically, looking to the interpretation of the law, what it says here is it would be really, really odd if this only applied to people within the state. So it'd be really, really odd if we read it to prevent the interaction of people from one part of a state to another part of the state, but didn't read it to prevent the interaction of people from outside the state to people within the state. And if you're going to restrict your own people, it would be really odd to allow the other people out in too. So, this should be applied to everybody. The object in view was to keep down as far as possible the number of persons to be brought within the danger of contagion or infection, and by this means of reduction to accomplish the subsistence and suppression of disease and spread of the same. Flattening the curve, baby. Flattening the curve. The particular places from which the parties were to be prohibited from entering the infection district or districts could not have any possible influence upon the attainment of the result to be attained. It wouldn't matter where you're from, because why would it? People are people, right? It shouldn't matter where you're from. People are people. It would make no possible difference where the added fuel to the infection sought to be excluded should come from Louisiana, New York, or Europe. Yeah, that makes sense. Referring to past conditions and past dangers which have arisen from them, the evils of what the statute 1898 was intended to remedy was pointed out as follows. So they're showing why the law exists. Why does the law exist? During the fall of 1897 and during the existence of an epidemic, a vessel arrived in the Mississippi River with immigrants aboard the same conditions, similar to those under which Britannia reached the same steam in 1898. The excited public discussions at the time as to the right of the state board under the then existing law to prohibit landing of immigrants and to its duty in premises was so extended as to authorize us to take judicial notice of the fact. And on our opinion, the clause in the present act, which covers the precise matter, was inserted therein for express purpose of placing a particular question outside the range of controversy. Okay, so basically what happened here, in 1897, there was a clause presumably dealing with the ability of people who are healthy to come into the jurisdiction that didn't yet exist. And so in 1897, there was a situation where they tried to do this, and there was a controversy because the law didn't explicitly state it. And the Supreme Court of Louisiana, I believe they're referring to at the time, the Supreme Court of Louisiana took judicial notice, which is basically when you take evidence of a fact as admitted, and basically said, or maybe it's interpretation, because I'm not sure exactly what they mean by notice in this sentence. So normally the way I'd read that today is, oh, this is judicial notice. This is admission of a fact. And so they're just saying this is the facts. But this sounds more like interpretation of law. So maybe they're using this language differently in 1898 or 1897 than they would today. So maybe when they say took notice, what they mean is they issued a decision that said this is the interpretation. And then because Louisiana is a civil law jurisdiction, not common law, right? So that means that the law is as it's written down. So unlike in common law, where the legislature wouldn't necessarily bother to write it down, because Louisiana is a civil law jurisdiction, because France, as a result, they amended the law to explicitly recite the recitation of the court. So that makes sense. So the court said, yeah, this is the law, and then the legislature said, oh, we're just going to amend it to take it past the issue, because we're a civil law jurisdiction. And so we have to, we're only as good as what's actually in the law. We don't do this common law thing the other states do. Don't ask me to explain civil law well outside my area of knowledge, but I do know if it's not written down, it doesn't count, mostly. And this is the, I believe, Supreme Court of Louisiana commenting on the law at the time. For a number of years, past immigrants have been coming into New Orleans in the autumn from Italy. There was probability when the General Assembly met in 1898, the epidemic of 1897 might be repeated. and in general probability immigrants would seek to enter, as they have the year before, to great danger not only to the people but also to the immigrants themselves. Independently of this, there was great danger to be apprehended from the increasing interaction between New Orleans and the West India Islands in consequence of a war with Spain. Yeah, this would be the Spanish-American War, right? That's the right period of time. Blame the Maine on Spain? Yeah. It was to ward off these dangers that the particular provision was inserted into the Act of 1898, and by implication from the reasoning just referred to, the existence of conditions rendering it necessary to call the power into play in this case before it was recognized. Louisiana remains a civil law country. Apologize, not country, state. Yes, Louisiana remains a civil law state. So Louisiana is still to this day governed by civil law, which means don't ask me to explain it, because it was not on any of my bar exams at any point ever. So I don't know what lawyers in Louisiana have to do to figure out the laws of Louisiana, but yes, to the best of my knowledge, there's still civil law, and so that aspect of France still remains because France. So yay. I also have two unrelated questions. What is where is the rest of my chat? Because I have 20 viewers and I want to know where is everybody. The Constitution doesn't apply supremacy clause, supremacy of federal law. Well, at least at this point, the law is a little bit different. I don't even begin to claim to know what the rules on getting waived into the courts of Louisiana are. If I have to I don't want to know. I don't know. I don't understand. Ozen said California is taking over hotels to house patients if needed. Does public necessity allow them to do so without compensation? I don't know. I'm going to say yes. There's probably a case that's specifically on point that specifically says that. But if I had to guess, public health emergency goes pretty far. So we're going to commandeer your hotels for the public health emergency without compensation. I'd imagine so. In the same way that when we discussed that case with the police who kind of blew up that person's house in order to get a criminal inside, and we said, oh, that isn't a taking because of the public safety aspect, probably the same aspect here. So, yeah, I would assume the state of California, if it is necessary, can seize hotel rooms for the purposes of housing patients, yes. Okay. And by implication from the reasoning just referred to, the existence of conditions rendering it necessary to call the power into play in the case before it was recognized. Thus, construing the statute, the state court held it was not repugnant to the Constitution of the United States and was not in conflict with any law or treaty of the United States. All latter considerations present the questions which arise for our decision. All the assignments of error relied upon to show the invalidity of the statute for the state of Louisiana, and hence the illegality of the actions of the Board of Health from the point of view of federal considerations are, in the argument at the barusement in four propositions. Wow, I don't know what that word is. Are in the argument at, they're two separate words without a space. That's why it doesn't make any sense. Two words with no space. So let me read it the way it should have been. From the point of view of the federal considerations are, in the argument at bar, summarized in four propositions. No wonder I couldn't figure out what that word is. We shall consider them separately and thus dispose of the case. In doing so, however, as to the first and second contentions, both rest upon assertions the statute violates the Constitution of the United States, and we shall treat them together. First, the statute in question, on its face, as construed and applied, is void for the reason that these are the arguments, by the way. These are the arguments. So these are the arguments as to error. First, the statute drawn in question on its face and as construed and applied is void for the reason that's in violation of Article 1, Section 3, Clause 8 of the Constitution of the United States, inasmuch as it vests authority in the Board of Health in its discretion to interfere with or prohibit interstate and foreign commerce. So it interferes with the Interstate Commerce Clause, which, doesn't really have the same meaning it does today. Secondly, the statute is void for as much as it conflicts with Section 1 of the 14th Amendment, in that it deprives the plaintiff of liberty and property without due process and denies equal protection of the law. All right, so these kind of arguments make sense, right? This may be a case from 1898, but we understand the logic of it pretty well. It's not too bad. Let me see if I can make it a little bit brighter on my camera. That's a little better. Now we can all see me better, which is very, very important. Now the court is speaking, it looks like. That from an early day, the power of the states to enact and enforce quarantine laws for safety and protection of health of inhabitants has been recognized by Congress is beyond question. Yeah, the police power, not to be confused with cops police, but the general ability of the government to do regulation, which is called the police power, is more entrusted to the states than the federal government. And so their ability to do things like this is sort of implied. Yeah. That until Congress has exercised its power on the subject, such state quarantine laws and state laws for the purpose of preventing, eradicating, or controlling the spread of contagious or infectious diseases are not repugnant to the Constitution, although their operation infects interstate or foreign commerce is not an open question. So basically, according to the United States Supreme Court, whatever the Interstate Commerce Clause authority might be, until the United States Congress does something to exercise its power, the states can do whatever they like. And that makes sense. That would be the same rule today, basically. We'd be talking about the Dormant Commerce Clause if we were talking about this today. We'd be talking about Dormant Commerce Clause, the ability of the government to regulate things in a way that impacts the Commerce Clause. So that would be the Dormant Commerce Clause. So we use slightly different language for it today, but the analysis is basically the same. The doctrine was elaborately examined and stated in a prior case. That case involved determining whether quarantine law enacted by the state of Louisiana was repugnant to the Commerce Clause. The court stated, and this is U.S., so that means this is a U.S. Supreme Court case. So they're referring back to themselves. The court said, is the law under consideration void as regulation of commerce? Undoubtedly, it is in some sense a regulation of commerce. It arrests a vessel on voyage, which may have been a long one, which I'm sure was, and may affect commerce among the states when the vessel is coming from some other state of the Union other than Louisiana, and it may affect commerce with foreign nations when the vessel arrested comes from a foreign port. This interruption of the voyage may last for days or weeks. It extends to the vessel, the cargo, the officers, and the passengers. Insofar as it provides a rule by which the power is exercised, it cannot be denied that it regulates commerce in some sense, right? We do not think it's necessary to enter into the inquiry whether, notwithstanding this, is to be classed among the police powers, which were retained by the states as exclusive to their own. We were talking about this, right? The power of the government to do stuff in general, all the power of the government to do stuff of any variety, pretty much whatsoever, is police powers. All the power of government to do anything is police powers. So that's probably a good way to think about it. So they're saying we don't think it's necessary to enter into this inquiry. It's to be classed among police powers, which were retained, and therefore not ceded to Congress. So basically, this is the idea of the supremacy of the federal government or not. So they're saying we don't need to get into the issue as to whether or not this is like a reserve power under the 9th or 10th Amendments of the Constitution. We don't need to get into the issue of whether this is a police power that even the Dormant Commerce Clause, which they're not using that language because that theory I don't think had been invented yet, but the same logic, right? So I'll put this in more modern day constitutional language, translate it a little bit into more modern day language because it's the same logical theory. So it's like, okay, the power of the state government to regulate stuff that interferes with commerce. Dormant Commerce Clause. Can we do that? So we look to the ability of things. And then they're saying, well, wait, there's a secondary issue. There might be the issue, and then maybe Congress can come back, which is exactly what you would be talking about in Dormant Commerce Clause, right? Because under dormant commerce clause, the state can only do stuff so long as the federal government doesn't stop them. But then it's like, aha, maybe we can come back from that again. Maybe even the ability of government to regulate commerce under the federal constitution isn't enough. Maybe there's an exception to the exception. Maybe there's an exception to the exception. Maybe there's a police power that even the federal government can't overrule. But we're not going to get into that issue because we don't need to. We don't need to figure out if this is a baseline police power that even the federal government can overrule or not. So, I guess I suppose there is a question. I suppose there is a question somewhere if it ever comes down to like a state trying to fight the federal government on a quarantine issue. Like, I suppose it might be the case that like the federal government might want to have one rule and like the state of New York or something might want to have a different rule. And Congress passes a law specifically saying you must. And the state of New York says, no, we're not going to. And then we're going to have a fight about it in terms of like the ability of the dormant commerce clause versus the ability of the commerce clause of the Constitution versus the ability of police powers versus the 10th Amendment. So yeah, in the event that like a state somewhere decides to enact regulations much stronger than the federal government wants, or like, in the event that the way I could see this happening theoretically is like if the federal government didn't care enough and they weren't going to institute a quarantine on planes landing at say LaGuardia from international flights. The state of New York says, no, we're going to do it. We're going to pass a quarantine. So you can't come in through LaGuardia. And the federal government says, but wait, it's our point of entry. It's our customs people. And the New York police say, no, screw you. That would be a situation where this would come up. So we say, okay, it's dormant commerce clause, but there's these, but there's this inherent police power and so forth and so on. So fun times heading by all that. Yeah. Brian Hayes asks, can a state criminalize gatherings of more than 250 people in relation to a public emergency? Well, they can't create new criminal law where it doesn't already exist. So they can't like create a criminal law out of nothing. But there's probably a law somewhere that allows them to publish regulations that the defiance of which would be criminal. So they can't like just on their own initiative pass a criminal law that says if you do this we're going to go to jail. However, there's probably a statute somewhere that says something like, anyone who's in defiance to any law, any regulation published by the Department of Health shall be punished, blah blah blah. So that would be legal. Probably exists. And also, as I was trying to allude to, if it's civil, they don't need to do that. So if what they're trying to do is like, you can't go to this and we're going to put police and, arrest you for obstruction, they could probably do that too. So, they can't invent new criminal law or something, but there's probably criminal law that applies one way or another. For a while, it may be a police power in the sense that all provisions for health, comfort, and security assistance are police regulations. An exercise of police power, it has been said more than once in this court that even when such powers are exercised, as to come within the domain authority of the Constitution, the latter must prevail. So even where they're exercising police power, the Constitution must win. But, again, there is a question there somewhere. Ozen asked, how did the federal government just make it the age to buy 21? Who is enforcing such laws? Good question as to the enforcement mechanism. I don't know as to how that was done in the enforcement mechanism. I'd have to look. But I think it was just tucked along into some like rider in a bill dealing with like a budget. So it was just like tucked away somewhere. And, without more, my case on point is South Dakota versus Dole, dealing with regulation of alcohol. South Dakota versus Dole says that they can string it on a percentage, although it can't be like a unduly extortionate percentage. I believe South Dakota versus Dole was 10% in that case of federal highway funds. So there is nothing preventing any state in this union from making the drinking age anything it wants. There's nothing preventing a state making the drinking age 16 if it wants. All it has to do is be willing to give up 10% of its federal highway funds. And that was ruled as a constitutional condition in South Dakota versus Dole. So I would imagine, without looking at it, that is tied to some sort of monies, because that's how Congress usually regulates these things, is bribes. There's some sort of monies that says, if you don't do this, we won't give you monies. And the state wants monies. So that's presumably how they're enforcing this. South Dakota versus Dole is the case that says they can. It may be conceded that whenever Congress shall undertake to provide for the commercial cities of the United States a general system of quarantine, or shall confide the execution of details of such a system to a national board of health or to local boards as may be found expedient, all state laws on the subject will be abrogated so far as they're too inconsistent. Okay, so this is, again, from a U.S. Supreme Court case, which suggests this question has been decided, although an earlier paragraph said it hadn't been decided, which seems a little confusing to me. But apparently, if there is a national board of health with sufficient authority, then it can publish any regulation at once and abrogate state boards of health. Apparently. Okay. This follows for two reasons. The Act of 1799, the main features of which are embodied in law, of the revised statutes, clearly recognizes the quarantine laws of states and requires the officers of the Treasury a conformity to their provision in dealing with vessels affected by quarantine. And this very clearly has relation to laws created after the passage of the statute, as well as those in existence, and when, by Act of 1878, certain powers in the direction of this were conferred upon the Surgeon General of the Marine Hospital Service. I suppose that would now be called the Surgeon General of the United States. So their title has changed. And consuls and revenue officers were required to contribute services in preventing the importation of disease. It was provided that there shall be no interference in any manner with any quarantine law or regulation as they now exist or hereafter may be adopted under state laws, shows very clearly the intention of Congress to adopt these laws or recognize the power of states. So there was a provision in federal law which at the time basically said states can have the rules they want. Okay. But aside from this, quarantine laws belong to the class of state legislation which, whether passed with intent to regulate commerce or not, must be amended to that effect and are valid until displaced or contravened by some legislation of Congress. Again, in the event that this ever comes up, it will be a reasonable challenge, notwithstanding all this language. I would, who would actually win in the end? It would be interesting, but it'd be interesting to see who actually won in the end under the modern law. So there's a lot of language here that's suggesting that if the Congress wants to, they can override the state powers. But I don't know, man. It would be interesting. It'd be interesting to see which way it goes. So if the state of New York wants to put in regulations tighter than the federal government does, and the federal government wants to make them not have tight regulations, it'd be an interesting fight. Again, in Louisiana versus Texas, the court was called upon to consider a quarantine law of the state of Texas, which by its term was applicable to and enforced both as interstate and foreign commerce. After referring approvingly to the state case we have above cited, the court, speaking through Chief Justice Furl, said, "It is not charged the statute is invalid, nor could it be if tested by its terms. While it's true the power vested in Congress to regulate commerce among the states is a power complete in itself, acknowledging no limitations other than those prescribed in the Constitution, and where the acts of states in the exercise of the reserve power come into collision with it, the latter must give way. It's also true that quarantine laws belong to the class of state legislation which is valid until displaced, and such legislation has been expressly recognized from almost the beginning." So this law would this language would tend to suggest that in a fight the federal government would win. This is pretty powerful language. So yeah, I think the reason I was sort of hesitating, because the way I was reading above is like, oh, this is more an open question. But this language, citing U.S. Supreme Court cases that basically say, oh no, the U.S. government can do this. So I'm like, well, that's a lot of language. The 26th Amendment, isn't the 26th Amendment the one that changes the voting age to 18? You want to repeal the 26th Amendment? Isn't it the one that changes the voting age to 18? You want to repeal the right of 18-year-olds to vote? Okay. That is a policy perspective. All right. Further, calling attention to the fact, as remarked by the court, the nature of things, quarantine laws, and relating to public health must necessarily vary with different localities, it was said. Hence, even if Congress had remained silent on the subject, it would have not followed the exercise of police power in the state in this regard, although necessarily operating on interstate commerce would have been invalid. Although from the nature and subjects of power of regulating commerce, it must be ordinarily exercised by national government exclusively, this has not been held to be so, where, in relation to public's particular subject matter, different rules might be suitable to different localities. At the same time, Congress could, by affirmative action, displace the local laws, substitute laws of its own, and thus correct any unjustifiable or oppressive exercise by state legislation. The only thing an 18 to 21-year-old can do anymore is vote, go to war, and into debt. Well, enter contracts and get married and start businesses and move from state to state with autonomy and, you know, stuff like that. Despite these conclusive adjudications, earnestly insisted in the argument at bar that correct application of appreciation of all the decisions of this court, the rule will be discovered the state may enact quarantine of other health laws for the protection of the inhabitant, but such laws, if they operate upon or directly affect interstate or foreign commerce, are repugnant to the United States, independent of whether Congress has legislated on the subject. Okay, so here, what's going on is the people that want this current Louisiana, and by current, again, 1898 current, they want this current Louisiana law to be invalidated. There's a whole bunch of language that says the states can do this unless the federal government comes in. A whole bunch of cases that say this. So what they're trying to say is, I have taken note of all your language that says this. However, I want to suggest you have been wrong, or at least incomplete. We don't need an act of Congress to override the state law. It doesn't have to be that way. Even if Congress hasn't done it, it's still illegal. So they're trying to argue, even in the absence of Congress acting, it's still illegal. To sustain this contention, a more copious reference is made to cases decided by this court where the nature and extent of power of Congress to regulate was considered, and the validity of state legislation asserted to be repugnant to such power was passed upon. To analyze and review numerous cases referred to in order to point out the want of relation to the question at hand, basically they're saying that the cases have no merit, but okay, would effect a review of whole subject of the power of Congress to regulate commerce in every possible aspect, and an analysis of practically the greater body of cases which this court involved a serious and difficult subject from the beginning. We shall not undertake to do so. So basically, the court has said in about 3 sentences, to do what you're trying to do, we'd have to basically discuss and re-examine a whole bunch of cases. And, no, we're not going to do any of those things. We're not going to re-examine a whole bunch of cases. So you want to argue basically like many, many decisions of the Supreme Court are wrong. No, we're not going to do that, but thank you for asking. No. We shall not undertake to do so, but content ourselves with saying, after duly considering the cases, we find them to be inopposite, that is, basically inapplicable, to the doctrine they're cited to sustain, and hence, when they're correctly appreciated, none of them conflict with a settled rule. So, inopposite is another way of saying that they have no applicability to the subject at hand. Not only are we not going to reconsider them, but they're also inopposite to mean that they have nothing to do with anything. So that it's like when we correctly appreciate them, which is another way of saying when we correctly interpret them, they have nothing to do with this issue. So, thanks for bringing it up, but they have nothing to do with anything. Okay. My lamp lacks the panache of Nate Brody's lamp? Really? Really? It's panache? It's a panache issue? Uh, I mean, I'm using a different bulb. I'm using Nate Brody's same lamp. I'm using a different bulb, though. You think I should put in the bulb it came with and see if that provides a different effect? We could try that, I suppose. We'll take a break after this and we'll change the bulb and see how that looks. I'm disinclined to ban Dirk. Dirk has been with us for a while. So Dirk gets some slack. The confusion of thought which has given it rise to the misconception of authorities relied upon, and which caused it to be supposed that there are an opposite to the case in hand, is well illustrated by the premise upon which the proposition, the cited authority are applicable rests. That proposition is thus stated in printed argument. Turning now to the decisions of this court, it be found the basis upon which has been upheld the exclusion, inspection, and quarantine laws of various states is that criminals, diseased persons and things, and paupers are not legitimate subjects of commerce. Okay, poor people aren't legitimate subjects of commerce. Wow, all right. There may be attendant evils, but they're not legitimate subjects of traffic and transportation, and therefore, in their exclusion or detention, the state is not interfering with legitimate commerce, which is the only kind of protection to the Constitution. Okay, this is the argument. Right? I don't know. It's a little unclear who's speaking at that point. It must be observed that this erroneously states the doctrine as concluded by decisions of the court previously referred to, since the proposition ignores the fact that those cases expressly and unequivocally hold the health and quarantine laws of several states are not repugnant to the Constitution, although they may affect foreign and domestic commerce, as many states, as in cases they necessarily must do to be effectuous, because until Congress has acted under the authority conferred on it by the Constitution, such state health and quarantine laws producing such effect on legitimate interstate commerce are not in conflict with the Constitution. Yeah. I do not have a PayPal link yet, no, because I have my own oppositions to PayPal as a company. So I've been attempting to avoid them. I may not be able to do that forever. But I've been trying to hold back. This implicates no limitation on the power to regulate health laws of subject to limited commerce. In other words, power exists until Congress has acted to incidentally regulate by health and quarantine laws, even although interstate and foreign commerce is affected, and the power to absolutely prohibit additionally obtains when the thing prohibited is not commerce, and hence not embraced in interstate or foreign commerce. True also was held of some cases referred to by the attorneys, that when the introduction of a given article was absolutely prohibited by state law, upon the asserted theory that healthy inhabitants would be aided by the enforcement of prohibition, it was decided that, as the article was thus sought to prohibit was a well-known article, and therefore was legitimate subject to interstate commerce, it could not be removed from that category by the prohibitive effect of state legislation. And yes, and yes, whatever it may say about me, I have fewer problems with YouTube than I do with PayPal. So, if someone calls me out as like saying, but you do business with YouTube, I have fewer problems with YouTube than I do with PayPal. That's just my personal metrics. If you evaluate that differently, but that's how I view it. So, okay. I definitely have issues with YouTube, but not to the point where I have not wanted to do business with them. PayPal, on the other hand, yeah. It has earnestly insisted that the statute, whose constitutionality is assailed on its face, is not a regulation, but an absolute prohibition against interstate commerce, and sought to sustain this contention by various suggestions as to the wrong which may possibly arise from a perversion and abuse by state authorities of the power by which the statute confers. Thus it is said, what is infectious and contagious disease is uncertain, and involves a large number of maladies. How many cases of such maladies are essential to cause a place to be considered as infected with them is left to the determination of the Board of Health. That board, it is argued, may then arbitrarily, upon the existence of one or more cases of any malady which may be deemed infectious or contagious, declare any given space or even the whole state infected and proceed to absolutely debar all interstate or foreign commerce. So this is a lot of power, right? So the argument is that, let's take this to the extreme case, right? So this is always a good way of reasoning to me. I like this way of reasoning. It's like, it's there's another name for it. It's called like the Mott and Bell approach. It is a logical fallacy where you go from like the easy case to the hard case and in between. But I don't find it to be much of a logical fallacy as a good way of thinking, because if we can't even agree on the most extreme case, there's no point in like trying to argue the narrower case. So like I will often, as a rhetorical tactic, say if we're talking about any issue like gun rights issues, maybe, you know, and you want to regulate guns, all right. So one of the things I might do is I might try to run to the wall on the other end and say, okay, well, can they like ban all guns of all kinds and all descriptions and all purposes and blah blah? Because I'm trying to find the outer limits of your theory. Because like if I can't find the outer limits of your theory, there's no point in arguing the narrower case, right? So it's the same thing kind of here. It's like, so what they're doing is they're taking it to the wall, right? They're taking it to the wall. So they're saying, aha, if we take this to the wall, what that would mean is that if a person coughs, that Madagascar can close all the ports. If one person coughs, that Madagascar can close all the ports. That would be what that would mean. So that would be the wall on the other end, right? So if we take it to the wall, do we say that that's legal or illegal? Let's find out. In cases like this, it has been repeatedly held that when the question is raised whether a state statute is a just exercise of state power or is intended by roundabout means to invade the domain of federal authority, this court will look into operation and effect of statute to discern purpose. So they can look to purpose. Yeah. But this implies we are to consider the statute as enacted and natural results from flowing from it. It does not import that we're to hold a state statute unconstitutional by indulging in conjecture as to every conceivable harm which may arise or wrong which may be occasioned by the abuse of lawful powers. So, we are not necessarily going to take it to the wall. We are disinclined to take your invitation to take this to the wall because, we're not going to take it. We're going to just look to see what has happened in reality, which I suppose is a reasonable thing to do too. There will be time enough to consider a case of such purported abuse if it's presented. So if a person coughs and Madagascar shuts down everything, we'll consider that. And for those of you who wonder why I'm talking about Madagascar, you need to play Plague Inc. Because otherwise this reference is going over everyone's head. It's also borne in mind, as said by the court in Louisiana versus Texas, if any such wrong shall be perpetuated, Congress could, by its affirmative act, displace local laws, substitute laws of its own, and thus correct any unjustifiable and oppressive exercise of power by state legislation. And the views which we have previously expressed suffice to dispose of contention that we're subjecting the vessel of plaintiff in error to the restriction imposed by a quarantine and health law of the state operating to deprive the defendant in error of its property without due process of law in violation of the 14th Amendment. And having been ascertained the regulation was lawfully adopted and enforced, the contention demonstrates its own unsoundness, since in the last analysis it reduced itself to the proposition the effect of the 14th Amendment was to strip the government, whether state or national, of all power to regulate providing health and safety of people. Yeah, no, we're not going to do that, no. When lawfully enacted, cannot be enforced against the person or property without violating the Constitution. The 14th Amendment does not go that far, no. In other words, lawful powers of government which the Constitution has conferred may not be exercised without bringing about a violation of the Constitution. Yeah, good times. Third, the statute as applied and constructed is void for the reason that it's in conflict with treaties between the United States on one part and Republic of France and Kingdom of Italy on the other part, guaranteeing certain rights, privileges, and immunities to citizens and subjects of the countries. So now they're arguing it's a violation of our treaties. Treaties, of course, would be part of the federal law. So treaties would beat this, presumably. Reliance is placed to sustain the proposition on the provisions of treaty concluded by the Kingdom of Italy in 1871, on terms of a treaty with Great Britain in 1815, also a treaty between the United States and Kingdom of Greece, and one concluded with the Kingdom of Sweden and Norway. The treaties of other countries than Italy are referred to by the theory that as treaties concluded with France in 1803, by which Louisiana was acquired. So we're literally talking about the Louisiana Purchase now. It was provided that France should be treated upon footing of most favored nation in the ports of the ceded territory. Therefore, the treaties in question made with other countries than France were applicable to France in error. So they're arguing the treaty that did the purchase of Louisiana made France a most favored nation, and therefore other things with other countries are not necessarily applicable. But okay. Conceding, arguendo, which is for the sake of argument, which is a wonderful word to use in law. I use it quite a lot in just normal speech, probably too much, but it's just too much fun to say. Conceding, arguendo, this later proposition, and therefore assuming all treaties relied on are applicable. So they're going to concede for the purpose of argument. So we're going to take your proposition, and we're still going to disagree with you. So assuming you're right, we think it clearly results from context that they're not intended to and did not deprive the government of the United States of powers necessarily inherent and essential to health and safety. Yeah, we don't think this treaty was intended to take away the right of the government to regulate health and safety. There was a good 2-part episode of Star Trek Next Generation, which I can't remember the name of, but the one of the things was that they wanted to stop a Klingon vessel, and they couldn't think of any other reason, so they decided to invoke health and safety regulations of the treaty in order to stop the vehicle. So health and safety is just as much valid in 24th century Federation law as it is in 19th century Louisiana law. So health and safety regulations and their ability of the government to do things in the name of health and safety have not become mooted even in the 24th century, according to the canon of TNG. Just want everyone to take note. Yeah. Without reviewing the text of all treaties, we adverted to the provisions one made in Greece, which is principally relied on. The text of the article and this provision to which is directed is reproduced. Okay, so now we're going to talk about the treaty. Article 15. It is agreed that vessels arriving directly from the United States to America as a port within the dominions of His Majesty, from Kingdom of Greece, or the Kingdom of Greece, at a port of the United States of America, and provided with a bill of health granting by an officer having competent power to that effect at a port whence such vessel shall sail, setting forth no malignant or contagious disease prevailed in that port, shall be subject to no other quarantine than as such as may be necessary for the visit of the health officer of the port to which the vessel has arrived, after which the vessel shall be allowed immediately to enter and unload cargo, provided always there shall be on board no person who during the voyage shall have been attacked with any malignant or contagious disease. That vessel shall not, during the passage, have communicated with any vessel liable itself to undergo a quarantine. So you can't have had contact with other vessels from the quarantine, yeah. And the country from whence they shall come shall not at that time be infected or suspected before their arrival. An ordinance has been issued in consequence of all the vessels coming from the country should be considered as suspect and consequently subject to the quarantine. It is apparent that it provides only a particular form of document which shall be taken by the ship of the Kingdom of Greece and reciprocally by those of the United States for the purposes of establishing infectious or contagious disease did not exist at the point of departure. But as plain from the face of the treaty, the provision as the certificate was not intended to abrogate the quarantine power, since the concluding section of the article in question expressly subjects the vessel holding the certificate to quarantine detention if, on its arrival, a general quarantine has been established against all ships coming from the port whence the vessel holding shall have sailed. In other words, the treaty having provided the certificate and giving it effect under normal conditions provides the subject of vessel holding the certificate to quarantine if, on arrival, such restriction has been established in consequence of infection deemed to exist at port of departure. Nothing in the treaty, we think, gives even color to the suggestion, and that was intended to deal with exercise by government of the United States of its power to legislate for safety and health of its people, to render the exertion of such power nugatory, great word, by exempting the vessels of the Kingdom of Greece when coming to the United States from operation of law. In other words, the treaty was made subject to the enactment of such health laws as local conditions might invoke, not paramount to them, especially where the restriction imposed on the vehicle's based vessel is based not upon conditions existing at the point of departure, but upon the presence of the infection or contagious malady at the point of arrival, which in nature of things could not be covered by a certificate relating to the health. Yeah. Fourth, the United States, the statute as applied is void for the reason it's in conflict with the laws relating to foreign immigration. This is another argument, right? The federal government has all the power when it comes to foreign immigration. So you're interfering with the federal government's power over immigration law. Yeah. In this argument at bar, the proposition embraces also claim the statute is void because it's in conflict with the Act of Congress entitled an act granting additional quarantine powers. It's also in conflict with rules and regulations adopted for the enforcement of both immigration law and quarantine law. The Immigration Act, to which the proposition relates, are those of various laws. Without undertaking to analyze the provision of the Act, it suffices to say that after scrutinizing them, we do not purport to abrogate the quarantine laws of several states and the safeguards which they create and the regulations which they impose on the introduction of immigrants are ancillary and subject to such quarantine laws. So far as the Act of 1893 is concerned, it is manifest it did not contemplate the overthrow of quarantine systems and the abrogation of power on the system of health and quarantine exercised by the states, because the enactment of state laws on these subjects would, in instance, affect interstate and foreign commerce. An extract of the law we would think would make this conclusion obvious is if reproduced at the margin. So reading a little bit between the lines, what the Supreme Court seems to be saying is yes, Congress can do this, but if they're going to do it, they got to be clear about it. We're not going to infer it. We're not going to assume it. We're not going to imply it. We're not going to look to some generous language. If Congress wants to do this, they probably can. But they have to actually do it. They actually have to do it. We're not going to do anything that, whatever. Yeah. An extract from Section 3 of this Act, which we think makes the conclusion, is reproduced. The supervising Surgeon General of the Marine Hospital Service, which presumably is the same thing as the Surgeon General of the United States now, shall immediately after this act takes effect examine quarantine regulations of all state and municipal boards of health, and shall, under direction of the Secretary of Treasury, cooperate with and aid state municipal boards of health in the execution and enforcement of rules and regulations of such boards, and the execution and enforcement of rules made by the Secretary of Treasury. Because, the National Institute of Health hadn't been invented yet. To prevent the introduction of contagious or infectious diseases in the United States from foreign countries and one state or territory or District of Columbia from another state or territory. All rules and regulations made by the Secretary of Treasury shall operate uniformly and no manner discriminate against any port or place, and such ports or places within the United States having no quarantine regulations under state or municipal authority, when such regulations are, in the opinion of the Secretary of Treasury, necessary to prevent the introduction of contagious or infectious diseases into the United States from foreign countries, or into the state or territory of District of Columbia from another state, and such forces within the United States, nor to find anything in the rules regulated adopted in execution of the power conferred to him in question, giving support to the contention. So at least under the operative law at the time, the Surgeon General, it appears, upon regulations promulgated by the Secretary of the Treasury, could put in places quarantines that would apply from state to state, so they can put in internal quarantines and external quarantines, so they can do all kinds of stuff. And, without looking, I'm pretty confident there's some version of this law in the federal books right now. So presumably this would be, rather than the Secretary of Treasury, it would be the Secretary of Health and Human Services, or the Secretary of Homeland Security, or maybe the Attorney General, because they often have this kind of authority to do this stuff. So presumably it's one of those people. But presumably one of those people could put in force regulations to shut down state-to-state travel, shut down state-to-foreign travel. They have a lot of power to do a lot of stuff. It follows from what has been said, the Supreme Court of Louisiana did not err in deciding the act in question was not repugnant, it was not in conflict of the treaties. So basically, it is a non-problem because although the government has a lot of authority to do stuff, they have not abrogated the authority of the state to do stuff. So long story short, this is the too long didn't read version of this. The federal government has the authority to put in place regulations relating to the health as it applies to both interstate and international commerce, travel from state to state, and otherwise, and impose quarantines. And at least under the operative law at the time, and I'm pretty sure today, the states can also do this and put in more stuff. So that is the relevant rules. So we are going to change the lighting because Dirk suggested it, and we like Dirk. So we're going to change the bulb in this lamp that I'm using and see if it makes me look better. So I'm just going to very briefly turn off the camera. We'll change the bulb, and we'll see if it makes me even more handsome than I am now. And we'll see what Dirk thinks. So I will be right back. All right, you guys ready for this? You guys are ready for this? We're about to do the reveal. We're about to do the reveal. You guys ready? Brace yourselves. What do we think? Better? Worse? No difference? See if I turn it down. No, that's too much. 7, 6, 5. 4 is pretty good. So, yeah. How are we liking this? I'm even whiter. That's true. I am even whiter. I can't get away from that. Let's see if I turn down the brightness just a touch. There we go. So Dirk, how much of an improvement are we looking at from before? Are we liking that a lot better? Okay, great. No difference? Haziz says no difference. All right, well, one notch down. Yeah. 4 bright, 3 too dim. Yeah, I know. I don't have anything in between the two. It's like all I can do is like just I can't adjust the white balance or the exposure. The only thing I can do is limit the brightness a little bit, so I can do this. That's pretty good. All right, we'll go with that. All right. So we read the first case. So let us read the second case. So, yeah, too long didn't read of the first case was the states can do what they like, Congress can do what they like, the government has the power to enact quarantines, they have the ability to restrict travel and so forth in the name of the health. Pretty interesting. All right. All right, so let's move on to case number 2. So now we're in 1904. We move forward a little bit, right? Like the onks for this reason, 100 brightness steps and color temps. Ooh, what is this? Onks? I need to like look into this. Ewim. Onks lighting? I'll have to look into that. I don't know, but this is the exact same lamp that Nate Brody uses, by the way. It's the exact same one now because I got it from his stream. So, I could also push the light a little bit further away so it's not quite right up on top of me. I can't put it much further away, but push it a little bit further. So it's not quite right up on top of me. Yeah, that's not bad. That's not bad. It does make the rest of my room look a little bit dark, but we can live. All right, let's get to the case. So now we're here with a case of Henning Jacobs versus Commonwealth of Massachusetts. If you have not already done so, please like the stream. I only have 29 people, which is a little bit lower, and I'm not sure why. Maybe people have better things to do on a Friday night. I don't know. This case involves the validity under the Constitution of the United States of certain provisions in the statutes of Massachusetts relating to vaccination. The revised law of the Commonwealth provide that the Board of Health of any city or town, if in its opinion is necessary for public health or safety, shall require and enforce vaccination and revaccination of all inhabitants thereof, and shall provide them with the means of free vaccination. Whoever, being 21 years of age and not under a guardianship, in other words, not incompetent, refuses or neglects shall forfeit a $5. So yeah, we have moved on to can the government forcibly vaccinate everyone, adults, children, everyone? Can they force everyone to do stuff? Yeah. All right. Well, we're learning more and more every day. Get the lighting better. So we have good lighting. We have a really good microphone. And then all we could really do next is improve the camera from a webcam, but it's not too bad. An exception is made in favor of children who present a certificate signed by a register that they're unfit subjects. Well, we are familiar with that, but that's the law that we're working with. Proceeding under the above statutes, the Board of Health of the City of Cambridge, Massachusetts, in 1902 adopted the following regulation. Whereas smallpox has been prevalent to some extent in the city of Cambridge and still continues to increase, and whereas it is necessary for speedy extermination of the disease that all persons not protected by vaccination should be vaccinated, and whereas, in the opinion of the board, the public health safety requires vaccination or revaccination of all inhabitants, be it ordered that the inhabitants of the city who have not been vaccinated be vaccinated. Okay. Subsequently, the board adopted additional regulation empowering a named physician to enforce the vaccination provisions, as directed by the board. The above regulations being enforced, the plaintiff in error, which is just another way of saying the person who's suing, right? He's alleging error. That's what you say. It's error. So this is a legal term. All right. So the plaintiff, we would say. We wouldn't necessarily say the plaintiff in error, because why? The plaintiff, Jacobson, was proceeded against by a criminal complaint in one of the inferior courts of Massachusetts. So now he's the plaintiff arguing error, that he was convicted, presumably. The complaint charged on the 17th day of July, 1902, the Board of Health of Cambridge, being of the opinion it was necessary of public health and safety, required vaccination and revaccination of all inhabitants thereof who had not been successfully vaccinated, and provide them with the means, and that the defendant, being over 21 years, had refused. The defendant, being arraigned, pleaded not guilty. The government put in evidence the above regulations and made proof tending to show that its chairman informed defendant that by refusing to be vaccinated, he would incur the penalty and would be prosecuted. They was offered to vaccinate without expense, and the offer was declined and refused. The prosecution having introduced no other evidence, the defendant made numerous offers of proof. But the trial court reached each and all the facts offered to be proved were immaterial and excluded all proof. So yeah, this is the prosecution basically had one witness, right? The prosecution basically had one witness. Hey, doctor, what do you have to say? Well, I informed him the thing was available for free, and I offered to give it to him, and he said no. Okay, thank you. No further witnesses. And the defendant said, I have a whole bunch of evidence. And the court said, but we're not going to consider any of it because none of it goes to the issue at hand. Right? Okay. The defendant, standing upon his offers of proof and introducing no evidence, asked for numerous instructions of the jury. So now we're asking for jury instructions, among which were the following. That the revised law of Massachusetts was in derogation of rights secured to the defendant by preamble of the Constitution and intended to subvert and defeat the purpose of the Constitution as declared in its preamble. It's sounding a little sovereign citizen-esque, but I don't think we invented sovereign citizens yet either, so. The section referred to was in derogation of rights secured to the defendant by the 14th Amendment, especially clauses of the amendment providing no state shall make or enforce any law abridging privileges and immunities of citizens of the United States, nor deprive any person of life, liberty, or property without due process of law, nor deny any person equal protection. That the section was opposed to the spirit of the Constitution. Well, that's always a really encouraging idea. Each of the defendant's requests for instructions were rejected, and he duly objected. The defendant requested the court, but the court refused to instruct the jury to return a verdict of not guilty. Make the jury say not guilty. And the court instructed the jury in substance that if they believed the evidence introduced by Commonwealth as satisfied beyond a reasonable doubt they was guilty, they would be warranted in finding guilty. And then they found him guilty. The case was then continued for an opinion of the Supreme Judicial Court of Massachusetts, and the exceptions sustained the action of the trial court and thereafter pursued the verdict to jury. So, we appealed, basically. We looked to appeal, and the appellate court said no problem. And he was sentenced to court to pay $5. And the court ordered that he stand committed until the fine was paid. You have to give us $5. Okay. So there was a vaccination for free. He refused it, and he was convicted, and he was sentenced to $5. Now, I'd like to take note here that while $5 doesn't seem like that much, two things. First of all, it's 1902, so $5 is a little bit more. Second of all, if $5 is constitutional, accepting the cruel and unusual punishment clause, presumably the statute could allow for a lot more, including prison time. So, because it's a criminal conviction. So presumably it would be just as legal for it to be $5 or some more amount or some amount of jail time. There's probably a limit somewhere under 8th Amendment jurisprudence, but it's a criminal law, so it could be a lot more. Justice Harlan offers the opinion of the court. We pass without extended discussion the suggestion that a particular section of law is in derogation. Although the preamble to the Constitution provides general purposes, it has never been regarded as a source of any substantive power or its departments. And that's very true. The preamble to the Constitution has never been given any operative effect. So it is more philosophical or aspirational in nature. It is poetry, not prose. So you can't use the preamble of the Constitution as a basis for pretty much anything. It is not operative. It's preamble. So that's a pretty good statement of law. Such powers only expressly granted in the body of the Constitution, and such may be implied from the granted. And, lest it be pointed out that swings both ways, because both the government and people have tried to use the preamble as a basis of power. The government has tried to say, aha, The preamble says we have the right to promote the general welfare, therefore we have the right to do whatever we want. And the Supreme Court has said no. And people have said, aha, they have the right to do whatever, and the Supreme Court said no. So, before you say, well, this is horrible, just think if it did have operative effect, what the government could do with it. So it's like, no, you can't do that. You have to find the support somewhere else. Ekin Onyx video flood fill light from Ekin, a Texas company. I'll look into it, Ekin. Thank you. Yeah, it looks like it's only $110. So I might pick that up. Well, it looks like there's a couple different ones, but I'll look into it. Cool. Although, therefore, one of the declared objects of the Constitution was secure blessings and liberty, no power can be exerted to that end by the United States unless, apart from the preamble, it's found somewhere else. So the government can't use it either. We pass without this discussion the suggestion the above section is opposed to the spirit of the Constitution. Undoubtedly, as observed by Chief Justice Marshall speaking for the court, the spirit of an instrument, especially of the Constitution, is respected not less in its letter, yet the spirit is to be chiefly collected chiefly from the words. Which sounds suspiciously like the spirit should be given no weight to me, but okay. We have no need in this case to go beyond the plain, obvious meaning of the words, which it's contended must control our decision. What, according to the judgment of the state court, are the scope and effect of the statute? What result was intended to be accomplished? These questions must be answered. The Supreme Judicial Court of Massachusetts said in its case, let us consider the offer of evidence which was made by the defendant. The ninth of the propositions which he offered to prove, as to what vaccination consists of, is nothing more than a fact of common knowledge upon which the statute is founded, and proof was unnecessary and immaterial. The 13th and 14th alleged errors involved matters depending upon personal opinion, which could not be taken as correct or given effect, merely because it made a ground to refuse to comply. Moreover, his views could not affect the validity of the statute, nor entitle him to be exempt. Yeah. The other 11 propositions of alleged error, all relate to the alleged injurious or dangerous effects of the vaccination. So all the vaccination moms out there who say this is going to harm my little child, pay attention. This affects you. The defendant offered to prove and show by competent evidence these so-called facts. Each of them in nature is such that it cannot be stated as truth, otherwise as a matter of opinion. The only competent evidence that could be presented in court to prove these propositions was the testimony of experts, given opinion, actual experts, yes. It would not have been competent to introduce the medical history of individual cases. Yeah, because, you can't, the plural of anecdote is not data, as they say, right? Assuming medical experts could have been found who would have testified in support, and it had become the duty of the judge, in accordance with the laws, to instruct the jury as to whether or not the statute is constitutional, he would have been obliged to consider the evidence in connection with facts of common knowledge, which a court will always regard in passing upon the constitutionality of the statute. He would have considered the testimony of experts in connection with the facts that for nearly a century, most of the members of the medical profession have regarded vaccination repeated intervals as preventative. And today this would be decided under, Daubert? The Daubert test for scientific reliability. So today we would use Daubert and basically say these experts who say otherwise don't get to play because they are not in line with the overall consensus. So yeah. Ewim, I'm just as an FYI, if you would like me to buy this light, you could, for example, provide a super chat of sufficient value that would pay for the light. So, it's an option that exists. Let's see, where was I? That while he recognized the possibility of injury to individuals from carelessness in the performance of it, that would be giving it, or in a conceivable case without carelessness, so that would be reactiveness, they generally have considered the risk of such injury to be too small to be seriously weighted against the benefits coming from discreet and proper use. So yes, it might be that a doctor screws up giving it to you. It might be you have an adverse reaction. But it's so low in probability given the need that, screw you. That's not what that says. And yeah, or Fry being your alternative, yes. Fry or Daubert, yes, either one. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1. 1 but legislature and courts have acted upon them with general unanimity. If defendants had been permitted to introduce such expert testimony as been support, it would not have changed the result. It would not justify the court in holding the legislature has transcended its power in enacting the statute on their judgment of what the welfare of the people demanded. It's also worthy of note that he didn't show it would actually have an adverse reaction to him in particular. It just seems like he was complaining in general. While the mere rejection of defendant's offers of proof does not strictly present a federal question, we may properly regard the exclusion of evidence upon the ground of its incompetency or immateriality in showing what the opinion as to the scope and meaning of the statute. Taking the above observation as indicating the scope, as is our duty, we assume for the purposes of the present inquiry that provisions require, at least as a general rule, that adults not under guardianship and remaining within the limits must subject to themselves to regulations adopted by the Board of Health. Is the statute so construed, therefore inconsistent with liberty secured to every person? The authority of the state to enact the statute is referred to what is called as police power, the state to do stuff. Thank you, Uriel. Great $5 for all your awesome videos. You rock. Thank you, Uriel. I do appreciate it, and I do like it. I do appreciate validation. So thank you for the $5 super chat. It keeps me going. It is deeply appreciated. Maybe we should have reward tiers. If you give me a $50 super chat, you can designate someone that I will ban. That could be good. That could be good for a future stream. Maybe when I get a lot of people, we'll have a reward tier. If you give a super chat $50, you can ban somebody. Ah, man, good times. Although this court has refrained from any attempt to define the limits of the police power, it is distinctly recognized the authority to enact quarantine laws and health laws of every description. Indeed, all laws that relate to matters completely within the territory and do not necessarily affect the operation of people of other states. Today, the interstate commerce clause analysis would come into it a little bit more because, Wickard hadn't been decided yet. According to settled principles, the police power of the state must be held to embrace at least such reasonable regulations established directly by the legislative enactment as will protect the public health. It is equally true a state may invest local bodies called into existence for the purpose of local administration with authority in some appropriate way to safeguard public health. The mode or manner in which these results are to be accomplished is within the discretion of the state, subject, of course, so far as federal power is concerned, only to the condition that no rule prescribing a state, nor any regulation adopted by a local government agency acting under the sanction of state legislation shall contravene the Constitution, nor infringe any right granted or secured. A local enactment of regulation, even if based in the police power, must always yield to the exercise of the general government of any police power it possesses under the Constitution. We come, therefore, to inquire whether any right given or secured by the Constitution is invaded by the statute as interpreted by the court. Is there a constitutional violation here? The defendant insists his liberty is invaded when the state subjects him to fine or imprisonment for neglecting or refusing to submit. That compulsory vaccination law is unreasonable, arbitrary, and oppressive, and therefore hostile to inherent right of every freeman to care for his own body and health in such a way as to him seems best. These arguments should seem very, very familiar, right? Right. Yeah. And the exclusion of such law against one objects to vaccination, no matter what the reason, is nothing short of an assault. But liberty subjected to the Constitution to every person within its jurisdiction does not import an absolute right in each person to be, at all times, wholly free from restraint. There are manifold restraints, to which every person is necessarily subjected for common good. On any other basis, organized society could not exist with safety to its members. Society based on the rule that each is a law unto himself. This sounds suspiciously sovereign citizen-esque. So all the sovereign citizens out there, pay attention. Society based on the rule that each one is a law unto himself would soon be confronted with disorder and anarchy. The Supreme Court tells the sovereign citizens to go away. Real liberty for all could not exist under operation of principle, which recognizes the right of each individual person to use his own, whether in respect to his own personal property, regardless of the injury of others. Sovereign citizens, eat it. This court has on more than one case recognized as fundamental principle that persons and property are subjected to all kinds of restraint and burdens in order to secure general comfort, health, and prosperity. of the perfect right of the legislature to do so, for which no one question ever was, or upon general principles ever can be made, so far as a person is concerned. I am liking this idea of a ban hammer contribution because I once read a comment in an IRC that said I get really really rich if I could invent a way to stab people in the face across the internet. So I can't do that, but I can, for the exchange of 50 of your dollars, allow you to ban someone and me get rich. This is the best idea ever. We are implementing this at some point in the future. So, save up. And maybe we'll have tiers to like give you some immunity for being banned. But not like we'll still have we'll have tiers. Like $20 so you don't get banned, but by the people at $50. So 50 people dollars can ban anyone who isn't at the $20 level. And if you contribute at the $20 level, you can't get banned by the people at the $100 level, and so forth and so on. So it's just how much protection do you want against getting banned? This is the best idea ever. I love this idea. Yeah, so yeah. Super chat didn't show up, but $20 out of your bank account. Well, if it didn't show up, it might be held by your bank, but not withdrawn if it's credit cards. But I don't know. But if you'd like to at me with your super chat comment, I'll be happy to read it. I will take your word for it that you tried, and I will read your comment for $20. And maybe it'll show up. I haven't gotten it yet, that's for sure, because I can see my chat revenue on my side. So it hasn't shown up to me, I can tell you that. So wherever the money is, it hasn't shown up on my end yet. The possession and enjoyment of all rights are subject to reasonable conditions as may be deemed by a government authority of the country essential to safety. Even liberty itself, the greatest of all rights, is not unrestricted license, is only freedom from restraint under conditions essential to equal enjoyment of the same right by others. It is then liberty regulated by law. In the Constitution of Massachusetts, adopted in 1780, it was laid down a fundamental principle of the social compact that the whole people convenes covenants with each citizen, and each citizen with the whole people, that shall be governed by certain laws for the common good. And that the government is instituted for the common good, protection, safety, prosperity, and happiness of all the people, not for profit, honor, or private interest of any one family, class, or man. So as long as we're doing it, equally to everyone, very good. The good and welfare of the Commonwealth, of which the legislature is primarily a judge, is the basis on which the police power rests. Oh, Matt Brown asked, what is my legal expertise? Well, thank you, Matt, for asking. My expertise is in intellectual property law, particularly patent law, particularly computer-related patent law. My undergraduate is computer science, and then I went and applied that to get law related to computer science. So my day job deals with computer search engines, databases, and back-end intellectual property as it relates to patent law. That's my day job. But at least on my stream, probably because it is my day job, I like to talk about pretty much anything else other than patents. All I do day long is talk about patents. And so when it comes to stream, I like to talk about anything else other than that because I already talked about it for 8 hours. I don't want to talk about it anymore. I want to talk about other stuff. Applying these principles to the present case, it is observed the legislature of Massachusetts required the inhabitants of city or town to be vaccinated only when, in the opinion of the Board of Health, it's necessary for public health or public safety. The authority to determine for all what ought to be done in such an emergency must have been lodged somewhere or in some body, and surely it was appropriate for the legislature to refer to that question in the first instance to a Board of Health, comprised of persons residing in the locality affected and appointment presumably because of their fitness to determine such questions. Ewim is saying, please ban me, Blackleaf. Please ban me. I don't want to continue being in this chat. Please ban me, Blackleaf. I don't want to be here anymore. Thanks, Ewim. To invest such a body with authority over such matters was not unusual, nor unreasonable or arbitrary requirement. Upon the principle of self-defense, of paramount necessity, community has the right to protect itself against epidemic of disease, which threatens the safety of members. It is to be it is to be obs- it is to be observed that when regulation in question was adopted, smallpox, according to recitals of a regulation, was prevalent to some extent in the city of Cambridge, and its disease was increasing. If such was the situation, and nothing is asserted or appears in record to the contrary, if we're attached any value to what knowledge whatsoever, it is safe to affirm, in common to all civilized people, touching smallpox and methods. Incidentally, I'm switching back to Zyrtec because I think for some reason Claritin causes my nose to itch, which isn't really good when everyone tells you stop touching your face. So I'm switching back to Zyrtec and seeing if that helps, because the Claritin helps with the allergies, but not as much as Zyrtec did. And yeah, so I'm switching back. Smallpox being prevalent and increasing at Cambridge, the court would usurp the functions of other branches of government if it judged, as a matter of law, the mode adopted under the sanction of the state to be protected to people at large was arbitrary and not justified by necessity. You went to law school to be a patent lawyer, but decided to be a field engineer, more money. That's fine. I first of all, I don't know how much field engineers get paid. Patent lawyers can get paid quite a lot, as I'm sure you know. So I'm not sure how the salaries compare, but okay. Second of all, it's not always about money. I just really, really enjoy law, and I don't enjoy engineering as much. So I'm happy where I am. This court recognized the right of a state to pass sanitary laws for protection of life, liberty, or health, or property within its limits, laws to prevent persons and animals suffering under contagious or infectious diseases, or convicts from coming within its borders. Okay, well, apparently under the case law at the time, and I don't know if that applies now, but apparently you can just ban conflicts. Okay. But as these laws went beyond the necessity of the case and under the guise of exercising police power, invaded by a domain of federal authority and violated by the rights, this court needed a duty to hold such laws invalid. If the mode adopted by the Commonwealth of Massachusetts for protection against smallpox proved to be distressing, inconvenient, or objectionable, if nothing could be reasonably affirmed to statute in question, the answer was the duty of the constituted authorities primarily to keep in view comfort and safety of many and not permit the interests of many to be subordinate to the wishes or convenience of the few. The needs of the many outweigh the needs of the few or the one. There is, of course, a sphere with which an individual may assert supremacy of his own free will and rightfully dispute the authority of any government, especially a free government, existing within the Constitution to interfere. $5 from Greg Polanski. Did it work this time? Yes, it did, Greg. Thank you for the $5. It is appreciated. But it's equally true that every ordered society charged with the duty of conserving the safety of members, the rights of individuals, in respect of his liberty may at times, under the pressure of great dangers, be subject to such restraint to enforce by reasonable regulations as the safety the general public may demand. An American citizen arriving at an American port on a vessel in which during the voyage there's been a case of yellow fever or cholera, he, although may be apparently free from disease, may in some circumstances be held in quarantine against his will on board of the vessel or in a quarantine station until ascertained by inspection, conducted with due diligence, that the danger of the spread of disease upon the community at large has disappeared. The government can keep you in quarantine for a reasonable period of time. The government can do things as long as they fit within the medical need. So as long as there's medical experts that are saying this, yeah, probably. The liberty secured by the 14th Amendment, this court has said, it consists in part of a person to live and work where he will, and he may be compelled by force against his will and without regard to his personal wishes or pecuniary interests or even religious or political convictions, to take place in ranks of the army of his country and risk the chance of being shot down in defense. I don't know the degree to which that would impact a conscientious objector, but presumably the way this is phrased, they could conscript even conscientious objectors. So I don't know. I'm pretty sure conscientious objectors are recognized by an act of Congress. I'm pretty sure the conscientious objector thing exists because congressional law says it does. But if it didn't, I think that they can conscript everybody. It said, however, the statute, as interpreted by the state court, although making an exception in favor of children certified to be unfit, makes no exception in cases of adults. But this cannot be deemed a denial of equal protection to adults, for the statute is equally applicable to all in like condition, and no obvious regulations where it may be inappropriate for adults, which could not be of safely persons of tender years. If he had actually had like demonstrable evidence as to him in particular, like I think he could have gone to court to go the other way. If he had shown like some reason it couldn't be administered to him for medical necessity, he probably could have gotten in court the other way. But it sounds like he was just generally being bitchy. Looking at propositions embedded in defendants' rejections of offers of proof, it's clear that they're formidable by number than their inherent value. you, they are formidable in the number of them, but not in the value of them. Yes, we have taken note that there are lots of them, none of which are worth anything. That's funny. I like that. Very good. Those offers in the main seem to have no purpose except to state the general theory of those in the medical profession who attach little to no value to vaccination as a means of preventing the spread of smallpox, who think that vaccination causes other diseases of the body. So all you people out there who think this is giving you some sort of medical condition, you can eat it. All the autism people out there, Jenna McCarthy people can eat it. What everyone knows, the court must know, and therefore the state court judicially know, as this court knows, the opposite theory accords with common belief and maintained by high medical authority. So even in the early 1900s, the Supreme Court said, yes, vaccinations work, and nothing in the last 200 years has changed anything. We must assume that when the statute in question was passed, the legislature of Massachusetts was not unaware of opposing theories and was compelled by necessary to choose between them. It was not compelled to commit a matter involving public health and safety to the final decision of a court or jury. It is not the function of a court or jury to determine whether one of two modes was likely to be effective. That was for the legislature to determine, in light of all information, as a policy issue. That's what legislature do policy. It could not probably abdicate its function to guard the public health and safety. The state legislature proceeded upon the theory, which recognized vaccinations as at least an effective, if not the best known way, to meet and suppress the evils of smallpox. The medical establishment in 1905, knew this to be true, and 115 years later, it's still true, guys. So Upon what sound principles as to relations existing between different departments can the court review this action? If there's any such power to review the action as a matter reflecting the general welfare, it can only be when which the legislature has done within a rule that if a statute purporting to be enacted to public health, public morals, or public safety has no real or substantial relation to that, or is beyond all question a plain, palpable invasion of rights secured by fundamental law. So, long story short, if the government calls something a health and safety regulation that is not those things, the courts will look at past that. And they will also look to, like, if it is no basis in something resembling reality. Right? So the government doesn't get to call everything health and safety. They only get to call health and safety. And they don't get to, go beyond the pale of what the medical would allow for. But, short of that, it's pretty wide. Whatever may be thought of the expediency of the statute, it cannot be affirmed to be, beyond question, in palpable conflict. Nor, in view of the methods employed to stamp out the disease, can anyone confidently assert that the means prescribed by the state to that end has no real or substantial relationship. It's because vaccines work, so good luck with that. Such an assertion would not be consistent with the experience of this in other countries whose authorities have dealt with smallpox. We know for a fact it works. We've seen it work. Please stop saying it won't work. We know it works. We've seen in reality it works. And they knew this in 1905, and we now know it works. So, stop saying it won't work. I don't know if we should be comforted or dismayed that there were vaccine deniers in 1905, and at least to that aspect, it doesn't seem to have gotten any better. Is that a good thing or a bad thing? I don't know. And the principle of vaccine as a means to prevent the spread of smallpox has been enforced in many states by statute, making the vaccination of children a condition upon the right to enter school, citing a bunch of cases. The latest case upon the subject we're aware is Weimeister versus White, decided recently by the Court of Appeals for New York. So that's the highest court in New York, because New York, being New York, decided to name things differently. Their trial court is called the Supreme Court. The intermediate court is called the Appellate Division. And the highest court in New York is called the Court of Appeals. So this is the highest court of New York, is the Court of Appeals, because New York. That case involved the validity of a statute excluding from public schools all children who had not been vaccinated. One contention was the statute and regulation adopted in exercise was inconsistent with rights, privileges, and liberties. The contention was overruled, the court said, among other things. Smallpox is known to be dangerous and contagious. If vaccination strongly tends to prevent the transmission, it logically follows children may be refused until they've been vaccinated. The appellant claims vaccination does not tend to prevent smallpox. Vaccine deniers in 1905, guys. But tends to bring about other diseases. Vaccine deniers in 1905. And does much harm with no good. Who knew Jenny McCarthy was alive and well in 1905? Who knew? It must be conceded that some laymen, both learned and unlearned, and some physicians of great skill and repute do not believe vaccinations are preventative of smallpox. Probably much less so today than in 1905. There probably were physicians in 1905 who believed that, but, not so much now, I'm pretty sure. And the common belief, however, is a decided tendency to prevent the small of the fearful disease and render it less dangerous. While not accepted by all, it's accepted by the mass of the people, as well as most members of the medical profession. It has been general in our state and most civilized nations for general. It is generally accepted in theory and generally applied in practice, both voluntary action of the people and in obedience to the command of law. Nearly every state in the Union has statutes to encourage, directly or indirectly, to require vaccination, and this is true of most nations in Europe. A common belief, like common knowledge, does not require evidence to establish its existence, but may be acted without proof by the legislature or the courts. The fact that a belief is not universal is not controlling, for there's scarcely any belief that's accepted by anyone, including vaccines are good. It will be really interesting to see, depending on how this current pandemic develops, if a vaccination becomes available someday, what the vaccine deniers will say that. I bet you dollars to donuts, that if the worst case scenario happens and this winds up killing like 1.5 million Americans in the worst case, that when they come out with a vaccine, there will still be people saying, but this vaccine will cause more harm than good and it shouldn't be applied to me. At which point the police will presumably forcibly hold you down and inject your ass. And I won't feel bad about it. So, yeah. In a free country where government is by the people through their chosen representative, practical legislation admits to no other standard of action. For what people believe is common welfare must be accepted as tending to promote the common welfare, whether it does in fact or not. Any other basis would conflict with the spirit and would sanction measures opposed to the Republican form of government. While we do not decide and cannot decide that vaccination is preventative of smallpox, because again, this is 1905, we take judicial notice of the fact that it's common belief, and with this fact as a foundation, we hold the statute in question is a health law enacted and is a reasonable and proper exercise of power. Fair enough. Since then, vaccination as a means of protecting the community against smallpox finds strong support in the experience of this in other countries. No court, much less a jury, is justified in disregarding the action of legislatures simply because it's of their opinion that particular method was, perhaps or not possibly, not the best method. Do the offers approved made by the defendant present a case which entitled him, while remaining in Cambridge, to be exempt from the operation of statute? We've already said that he rejected offers, in the main, only set forth on the theory of those who had no faith in vaccination as a means of preventing small spread of smallpox, or thought vaccination, without benefiting the public, put in health. Okay, so basically he just generally argued that there are problems. But there were some offers which is contended embody distinct facts that might have been considered. So the court is saying, well, the court is basically saying, well, in your argument, you bought onto the anti-vaccine bandwagon for some reason we can't begin to fathom, and neither can I. And so, none of this is relevant to you. We don't know why your group thinks vaccines are bad. Okay, we don't know, but maybe there's something specific to you. Let's see. Let's see how it is. The defendant offered to prove that vaccination quite often caused serious and permanent injury to health. That operation occasionally resulted in death. Like 1 in a million, yeah. It was impossible to tell in any particular case what the results of the vaccination would be or whether it would injure the health or result in death. It's quite often one's blood that has a certain condition of impurity when it's not proven or safe to vaccinate him. There's no practical test to determine with any degree of certainty whether one's blood is in such a condition of impurity as to render it unsafe or dangerous. The vaccination is quite often impure and dangerous to be used. Probably not true in 1905, definitely not true today. But whether it's impure cannot be ascertained by any practical test. The defendant has refused to be vaccinated for a reason he had, a child, been caused great and extreme suffering for a long period by a disease produced by vaccination. Debatable at best, I'm sure. And they witnessed a similar result of vaccination, not only in the case of his son, but in the case of others. Correlation is not causation. Hello, Courtney Grace. Hello, howdy from the Commonwealth. Which one? Which Commonwealth? Commonwealth of what? If you're referring to the United States, there's 4 states that call themselves Commonwealths. Do you mean Virginia? Do you mean Pennsylvania? I don't know. These offers, in effect, invite the court and jury to go over the whole ground gone over by the legislature when enacted. The legislature assumed some children, by reason of condition, might not be fit subjects, and it is suggested, and we will not stay without reason, that may be the case for such an adult. But, and here's the critical part, I'm pretty sure, right? The legislature considered children, and it might be true for some adults, but this is the critical part, I'm pretty sure. But the defendant did not offer to prove that by reason of his condition that he was not fit. Ta-da, right? So, you didn't offer to prove as to you in particular. As to you in particular, even if the legislature had not explicitly contemplated it, you probably would have gone somewhere. But you didn't offer that. What you offered is vaccines are bad because reasons. Nope. The defendant did not offer to prove that by reason of his condition, he was not, in fact, a fit subject of vaccination, as was informed by the regulation. It's entirely consistent with his offer of proof after reaching full age. He has become, so far as medical skill could discover, and when informed, he was, in fact, a fit subject of vaccination. And vaccine matter to be used in this case was such that any medical practitioner of good standing would regard it as proper. The mature opinions of medical men everywhere and experience of mankind, as we all must know, negative the suggestion it's not possible in any case to determine whether vaccinations are safe. Yeah, it's like we take notice of reality. we take notice of reality that both in our country and other countries, people have been using these vaccines. Seems to be okay. Seems to be okay, especially as compared to the alternative of smallpox. Yeesh. Was the defendant exempted from operation statute simply because of his dread of an evil result that experienced him when he was a child and observed in his case of the children of other children? Could he reasonably case an exemption because quite often or occasionally, in other words, unbelievably rarely, injury had resulted from vaccine, or because it was impossible, in the opinion of some, for there to be a practical test to determine with absolute certainty whether a particular person would become vaccinated? That's impossible today and later. I'm a big fan of vaccines. Everyone should get vaccinated. Get all the vaccines. People who are vaccine deniers I don't understand. It is difficult. In light of objective reality. It's like we don't have to guess. We can just observe what actually occurred. Iron lung machines are much less common than they were. It's probably good. We are not prepared to hold a minority residing or remaining in any city or town where smallpox is prevalent, enjoying general protection afforded by an organized local government, may then defy the will of its constituted authority, acting in good faith for all under legislative sanction. If there be such a privilege of a minority, then a like privilege would belong to each individual, and a spectacle would be presented of the welfare and safety of an entire population being subordinated to the notions of a single individual who chose to remain part of that population. Vaccine deniers can eat it. We're unwilling to hold it to be an essential element of liberty secured by the Constitution that one person or a minority of persons residing in any community and enjoying the benefits of the government should have the power to dominate the majority when supported in their action by the authority of the state, while this court should guard with firmness every right appertaining to life, liberty, or property as secured to the individual by supreme law. It is of the last importance that should not invade the domain of local authority except where it's plainly necessary to do so in order to enforce the law. The safety and health of the people of Massachusetts are, in the first instance, for the Commonwealth to guard and protect. Yes, one of the legitimate roles of government is to protect for health and welfare of all of us collectively. And you are ruining that, so we're going to hold you down and inject you. Yep. There are matters that do not concern the national government, that do not ordinarily concern. So far as can be reached by any government, they depend primarily upon such action as the state, in its wisdom, may take. And we do not perceive this legislation has invaded any right secured by the federal Constitution. But before closing this opinion, we deem it appropriate, in order to prevent misapprehension as our views, to observe, perhaps to repeat what a thought already sufficiently expressed, namely, the police power of a state, when exercised directly by the legislature or local body, may be exerted in such circumstances or by regulations so arbitrary and oppressive in particular case as to justify the interference of the courts to prevent wrong and oppression. So the court is going to take an additional note, even though they kind of already said it, but they want to say it very clearly. There is a line. There is a line somewhere, right? There is a line. Governments can, through health and safety or whatever, oppress people. And we are not like idiots. We are not idiots. We realize that if we say, hey, government, you get to do whatever you want on health and safety, everything becomes health and safety. So there is a line. There is absolutely a line to be had. And that line, as I'm sure the court is about to tell us, is based on reasonableness of the situation and based on the facts and knowledge and medical consensus as it applies to vaccines. And so, if the government just arbitrarily decides you have to do something someday for no reason because of health and safety, no. There is a limit. We recognize there's a limit. You do have autonomy, even from the majority, when the government is behaving arbitrarily and capriciously. Yeah. Extreme cases can be readily suggested. Ordinarily, such cases are not safe guides in the administration of law. It's easy, for instance, to suppose the case of an adult who is embraced by mere words of the act, but yet subject to whom the vaccine in a particular condition of his health or body would be cruel and inhuman in the last degree. We are not to understood as holding the statute was intended to apply to such a case, or if it was so intended, the judiciary would not be competent to interfere and protect the health of the individual concerned. So yes, if we're pointing out that there might be a person for whom this would be inhuman for a variety of reasons, and we're saying we don't understand the statute was intended to apply to this. We understand that they exempted children, but even though they didn't exempt adults, and normally, when you say one and you don't say the other, you assume excluded. But we're just going to read it in anyway. We don't assume you intended it, and even if you did, even if you intended to inflict this upon a person to whom it would be cruel and unusual, in that situation, the courts might intervene, yes. There is a limit somewhere. All laws, the court has said, should receive a sensible construction. General terms should be limited in their application and not lead to injustice, oppression, or absurd consequences. It will always, therefore, be presumed the legislature intended exceptions to its language, which would avoid the character. Yeah, so we generally assume the legislature are not complete idiots. And we assume that even if the legislature didn't say so and seemed to leave it out, we assume they're not complete idiots, and we assume that they knew it as given or something, or they were having a bad day or something. We're just gonna assume they didn't want absurd results. We're not stupid, and we assume the legislature isn't either. The reason of law in such cases should prevail over its letter. Yes. Letter of the law must eventually bow to realities. So, like, eventually reason does beat the letter of the law. The letter of the law, it's like, yeah, there's like letter of the law, and it's like, this doesn't make any sense. Until otherwise informed by the highest court of Massachusetts, we're not inclined to hold the statute establishes an absolute rule. The adult must be vaccinated. We're not going to read it this way. We're not going to read it this way because they didn't mean it this way. Must be vaccinated if it's apparent or can be shown with reasonable certainty he's not at the time subject fit to be subject, or the vaccination by reason of his condition would seriously impair his health or probability cause death. No such case is presented. It is the case of an adult who, for aught that appears, was himself in perfect health and fit subject to vaccination, yet while remaining in the community refused to obey the statute and regulation, adopted in execution of provisions for the public protection of health and public safety confessedly endangered by presence of dangerous disease. We now decide only the statute covers this present case, and nothing clearly appears that would justify this court in holding it to be unconstitutional and inoperative as to its application to the plaintiff in order. So yeah, we are basically saying, that there is a line somewhere. We assume the legislature didn't mean this absolutely, because that would be dumb. And if you would come forward with specific evidence as to you, yeah, a court might be able to intervene. But you're not there. You look perfectly healthy. Everything seems fine. So, just because there is a literal 1 in a million chance this will kill you, eat it. Sorry. Yeah. And then we have a really short decision, so it's not as long as the other ones. Zucht versus King, 1922. This is relatively short. This deals with public school vaccinations specifically. So we'll read that. Ordinance by the city of San Antonio, Texas, provide that no children or other person shall attend a public school or other place of education without having first presented a certificate of vaccination. This is 1922. This is 98 years ago. They're requiring vaccination certificates for public school admissions. And we're still having the same argument 98 years later. Sometimes I don't understand people, man. Sometimes I do not understand people. Purporting to act under the ordinance, public officials excluded Rosalind Zucht from public school because she did not have the required certificate and refused to submit. They also caused her to be excluded from a private school. Thereupon, Rosalind brought this suit against officials. The bill, that would be the lawsuit, charges that there were no occasions for requiring vaccination. Ordinance deprived plaintiff of her liberty without due process and by making vaccination compulsory, and that they were void because they leave to the Board of Health discretion to determine when and under what circumstances the requirement shall be enforced without providing any rule by which the board is to be guided by its action, without providing any safeguards against partiality and oppression. Well, geez, we just read 2 other cases that said exactly this same stuff, right? This is just the exact same argument we saw twice already, right? So, but now we're going to read it for a third time. We're going to read the same argument for a third time. It's the same exact argument for a third time. Let's do it for a third time. 3-time champion. The prayers were for an injunction against enforcing the ordinance. Prayers, again, is a legal term of art. That would be like request or your claim of relief, right? It's called a prayer for relief a lot of times. So the prayers here are for legal relief. Why they're called prayers, I don't know, but that's what we decide on. Deal. The prayers were for injunction against enforcing the ordinance. For writ of mandamus, that is in order to do stuff, to compel her admission to a public school, which would be the right cause of action. That would be the right cause of action. I want a writ of mandamus. Make them admit me. That would be the right cause of action. So at least you're asking for the right thing. That's a nice thing. Stuff. Right. A general demur to the bill of complaint was sustained. So a demur is like an objection, or it's a response. Basically, no. So a general demur, the plaintiff is saying, make them, and the defendant is saying, no, don't make me. So that would be a demur, right? All right. So it's a general demur was sustained. Plaintiff having declined to amend, so you can't amend your action, the bill was dismissed. The lawsuit was dismissed. The judgment was affirmed by the Court of Civil Appeals for the 4th Judicial District of Texas. The motion for rehearing was overruled. Application for writ of error to the Supreme Court of Texas was denied. This person is really interested, man. It's interesting here that they write the Supreme Court of Texas, because the Texas has 2 Supreme Courts. And so, like, has that always been true, or is that a relatively recent development? I'd be interested to know. Because being admitted to Texas, hopefully in the near future, presumably I will have to know why Texas has 2 Supreme Courts, one for civil and one for criminal. But they just call it the Supreme Court of Texas. So at this point in history, was there only one Supreme Court? And if so, why did they split them? I don't know. That's an interesting question. I don't know. A petition for writ of certiorari filed in this court was dismissed for failure to comply with a rule. The case is now here on a writ of error granted by the Chief Justice of the Court of Civil Appeals. It is assigned as error that ordinance violated due process and equal protection, and is administered they deny plaintiff equal protection. We've seen this really, yeah. Colion Noir does some good legal stuff on the Second Amendment. He also does a lot of gun shooting videos, but he's a lawyer out of Texas, I believe. And he does some law stuff on his channel. So Colion Noir, he doesn't do all law. He does a lot of gun reviews and gun videos, but, you know, he's a reasonable guy to look at for lawyers who do the Second Amendment. I'd be happy to do more Second Amendment stuff, you know, feed me cases. I'll be happy to talk about it. The validity of ordinances under the federal constitution was drawn in question by objections properly taken. A city ordinance is a law of the state within the meaning of the law, which provides review for a writ of error with a validity of law sustained by the highest court in which a decision could be had. But although the validity of the law was formally drawn in question, it's our duty to decline jurisdiction when it appears the constitutional question presented is not a time of grant been substantial in character. So the rules dealing with when the Supreme Court had to take cert might have been different at this point. I'm pretty sure they were different because it's more discretionary now. So I'm not sure what the rules were at the time okay. Long before the suit was instituted, a prior case has settled that it's within the powers of the state to provide for compulsory vaccination. That case and others had also settled that the state, consistent with the federal constitution, delegate a municipal authority to determine under the conditions. Do you see? Because we didn't even describe Jacobson versus Massachusetts. That was a United States Supreme Court case. We're just going like there. This has come up a couple times, guys, before the U.S. Supreme Court. They've considered this issue a couple times. Matt Brown, that can't possibly be true. It can't possibly be true that all Second Amendment laws are unconstitutional. Unless, I mean, that doesn't make sense any more than it would in the First Amendment context. You know, the First Amendment says Congress shall make no law. The Second Amendment says shall not be infringed, right? Shall make no law and shall not be infringed sounds sufficiently close to my ear that mutus mundus, you can apply one to the other. And there's like 80 years of case law deciding the First Amendment and the varying degrees thereof. So, like, you know, unless you want to argue that 80 years of, like, First Amendment law is wrong, then I don't know how you can hold the proposition that all laws under the Second Amendment are automatically unconstitutional. That, you know, I don't know, like, how that would work. So unless you want to say, like, all laws trying to restrict freedom of speech are unconstitutional, and the Supreme Court's been getting it wrong for 80 years, which I suppose is a view you could have. Unless you want to say that, I'm not quite sure how you could hold the view that all laws dealing with the Second Amendment are necessarily unconstitutional. That doesn't make sense to me. Yeah, the First Amendment says Congress shall make no law. Second Amendment says shall not be infringed. Sounds sufficiently close. Mutus mundus. It must be the case that there's stuff that can pass Second Amendment muster. What those things are, of course, is a whole other subject to debate. But that seems a very strange proposition. That case and others had also settled the state must make consistent with law, delegate to a municipal authority to determine the regulations. And still others had settled the municipality may vest its authority in officials, broad discretion, A long line of decisions by this court has also settled that the exercise of police power, reasonably classification may be freely applied, as the regulation is not violative of equal protection merely because it's not all embracing. In view of these decisions, we find the record no question as to the validity of ordinances. Unlike in a prior case, these ordinances confer not arbitrary power, but broad discretion required for protection of public health. Yeah. 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 Well, again, Matt, I would say like the First Amendment says Congress shall make no law. So it's shall in the First Amendment too, right? Congress shall make no law. And in the Second Amendment, it says shall not be infringed, right? So in both the First Amendment and Second Amendment, you have this word shall. Congress shall make no law. Shall not be infringed. Okay. So again, like it seems to me that unless you're going to say 80 years of First Amendment law are wrong, because shall means shall without exception. There are no exceptions. So all that First Amendment analysis is therefore wrong, because the First Amendment says Congress shall make no law, and here's some laws that are being upheld. So unless you're going to say like 80 years worth of First Amendment law is wrong, then it can't be the case that the Second Amendment's shall isn't absolute any more than the First Amendment shall is an absolute. It's the same exact word twice. So, yeah, that's what I'd say. The bill also contains I'll just translate this language. The lawsuit also contains arguments to the effect the administration of the ordinance to the official having discriminated against plaintiff in such a way was to deny equal protection. These arguments do not present a substantial constitutional question, but the question is not of the character which entitles the litigant to review by this court on a writ error. The question does not go to validity of the ordinance, nor does it go to validity of the officials. This charge is of an unconstitutional exercise of authority under ordinance which is valid. Unless the case is otherwise properly here on a writ of error, questions of this character can be reviewed by this court only upon petition and therefore dismissed. So I told you it was a short case. I told you it was a short case. I don't remember at any point saying that the Supreme Court was perfect, Matt. There are many cases of the Supreme Court, including unanimous ones, that I disagree with. For example, Chevron or Brand X. Brand X, I don't think was unanimous, or Wickard v. Filburn. So no, the court isn't perfect. I don't remember saying the court was perfect. I do remember saying that to make the argument you're making, you not only have to say like there are First Amendment decisions which are wrong, which is obviously a much easier proposition to say some decisions are wrong. To make the argument you're making, at least in my view, you have to make the argument that the entire like philosophical construct of the First Amendment for 80 years is wrong. So basically, they're all wrong. That's a much different proposition. If you want to say the Supreme Court got it wrong in free speech case, whatever, we can have that discussion. Maybe they did. Maybe they got it wrong in a particular case, right? Just like maybe they got it wrong in a particular Second Amendment case, right? The Supreme Court can make mistakes. I don't recall saying they're perfect. They're definitely not. But what I'm saying is much different than that. I'm saying the First Amendment says Congress shall make no law. I'm saying both the Congress and states have passed laws that restrict or deal with the First Amendment. And I'm saying the court has, for 80 years, give or take, upheld these laws in general, because obviously they struck a lot of them down too, but in general, they have upheld these laws under various standards of scrutiny, right? Everywhere from unprotected defamation to like commercial speech, intermediate, viewpoint neutral speech, subject matter neutral speech, time, place, manner restrictions, political speech, right? We've got entire frameworks of First Amendment speech. So I'm not saying like you can't say that that the court didn't get a case wrong. I'm saying to make the argument you're making on the Second Amendment, you have to make the argument that they got the entire framework wrong, the entire philosophical framework, because there's a whole bunch of laws that have been upheld. So they'd have to all be wrong in gross. That's the only way that makes sense. Because if the Second Amendment really means shall not be infringed means if shall not be infringed means that all laws that attempt to regulate firearms are unconstitutional, if that's what that means, it would seem to be logically required to say that all laws that attempt to regulate speech are unconstitutional under the First Amendment, because shall and shall is the same word twice. So if you want to argue all firearm laws are unconstitutional under the Second Amendment, then it seems to me you have to argue all speech laws are unconstitutional under the First Amendment, which is obviously not the case. Therefore, you also have to argue the Supreme Court has been wrong in gross for about 80 years on First Amendment law, which I suppose is a view you can take. It is a perspective to take. I just want you to understand the full implications of the view that you're arguing, right? If you want to make the argument that like the Supreme Court has gotten it wrong in gross for 80 years, then you can, I suppose, make that argument. It's obviously a much harder argument, but it's a possible argument. But I just want you to understand that that's basically the argument that you're having to make. Because if all Second Amendment laws are unconstitutional, all First Amendment laws are unconstitutional, because the Second Amendment says shall and the First Amendment says shall. Therefore, mutus mundus, it must be true. The Supreme Court has gotten it wrong for 80 years. So I just want you to fully understand the implications of this perspective. For you to be right, the Supreme Court has to have gotten it massively wrong for a century. So, good times. The first Second Amendment case to come before the U.S. Supreme Court, I don't know, probably Miller. I don't know if it's the first ever, but it's the first notable one. Yeah, so, yeah. Yeah. Was the Supreme Court wrong in Sullivan? I don't know if they were wrong in Sullivan regarding politicians. I think you can make the logic of Sullivan is probably better argued under the right of petition for redress of grievances rather than freedom of speech. But I think the rationale of it works. As it applies to figures beyond politicians, though, it's a little bit more dubious. And you can definitely make a case that's been extended beyond what it should have been. Too many people are public figures. That it hasn't been sufficiently constrained and it's been overly extended. I think that's an easy argument. And yes, obviously, arms doesn't just mean firearms. So all regulations dealing with arms of all varieties would have to be unconstitutional, which, I think so. Yeah. Yeah. Yeah, so yeah, I'm switching to Zyrtec, so I'll touch my face less, because the Claritin seems to cause a lot of itchiness in my nose, and so, but I've been washing my hands very thoroughly, so I'm trying to practice hygiene there. So, malice of forethought is a confusing phrase. Yeah, there's a lot of confusing phrases like that. Malice of forethought, and there's one also, it's like deprivation of the heart or something. It's a little bit weird. Yeah, so Black's Law Dictionary, to someone who asked, Black's Law Dictionary is not God. Black's Law Dictionary is a private publication, which, like all private publications related to law, tries to be accurate. But, Black's Law Dictionary is at best the start, not end, of any discussion. So if in any discussion someone says Black Law Dictionary says X and stops, they're probably wrong. Because, there's a lot more than that. Yeah. All right. So I'm going to end the stream. I hope you enjoyed this special edition of Supreme Court React. I hope you enjoy all this stuff. So, for the people who have been watching and listening, I value your likes. I value this stuff. I really appreciate having you. And that's all for now. So remember to stay healthy out there. Ricardo Ospania gives me $5. Miller seems to say only military style weapons are legal. Yeah. I'm of the view that Miller is just not a well-written decision. Miller is just a mess. You know, you can't even say that Miller is right or wrong because it's just so like it's just not well written. Not every case from the U.S. Supreme Court, I guess, can be wonderful, and that was one where it was not wonderful. Like you can read Miller to say almost anything you want to say. It's just not a very well written decision. So like I wouldn't really rely on Miller for pretty much anything. It's just not a good decision. It's like it's yeah. Why soft shotguns were apart? The art where soft shotguns were used in World War One. Yeah, this I would just kind of ignore Miller just because it's not well written. It's not well reasoned. Not for the least of reasons, and I've mentioned this in another stream. Not for the least of reasons that Miller himself didn't show up to the Supreme Court. And someone said it might have been because he was dead at the time, but I'm not sure. But either way, the only person that showed up to the Supreme Court was the government. Miller didn't show up. No one argued for Miller. The only person that gave argument before the U.S. Supreme Court was the U.S. government. They're the only ones who showed up. And so is at least partly that reason, I think, that the case is just weird. It's not well written, and I would ignore it. $2 from Furby Slayer. Left a question on Mitch versus Wisconsin when you have time. Left a question where? I'd argue Mitchell versus Wisconsin is wrong. What is Mitchell versus Wisconsin? Let's see. Let's Google that really fast. Mitchell versus Wisconsin. It's 2019, U.S. Supreme Court. Okay. Oh, yes. We covered this case. Yeah, no, I don't think it was wrongly decided. I don't think it was wrongly decided. The implied consent laws I think get you there, and so yeah, I don't think it was wrong. I don't think it was wrongly decided, but that's my view. Yeah. Anyways, I'm gonna sign off, guys. Stay safe out there. Later, bye.